Court does call the case of the people of the state of Michigan versus Sherrone Moore. Counsel, please state your appearances for the record.
Good afternoon, Your Honor. Katie Rismersky for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sherrone Moore, who is present in court.
Your name, sir?
Sherrone Moore.
All right, thank you. Grab my file back. All right. Your time set for a probable cause conference. What do we need to do today?
I've had the opportunity to talk with the prosecutor. There is outstanding discovery that we need to have before we can proceed to exam. So we're asking to adjourn the probable cause conference.
Okay, pause right here. A probable cause conference is basically the checkpoint before the preliminary exam. And when the defense asks for 30 days, that usually means one thing. There's discovery out there that could matter. Phone records, university documents, possibly credibility evidence. Translation? The defense isn't ready to swing yet. They're still gathering ammunition.
For 30 days to receive that discovery. And the discovery, we're talking about our phone records and Title IX documents.
Okay. Are the people going to be in possession of Title IX documents or have access to those, I guess?
It's a very good question, Your Honor.
Thank
My best understanding.
I usually ask good ones, but
You do.
go ahead.
This court always does. My best understanding in the moment is that this is not a Title IX investigation per se.
Now, this is where it gets interesting. Not a Title IX investigation per se. That wording matters. If it's not formal Title IX, then what exactly triggered this? An internal complaint? An informal inquiry? These distinctions can dramatically impact what records exist and whether they're obtainable. Viewers, let me ask you, if credibility is central, how important are those earlier statements going to be?
Say, my information is coming in real time, as they also say. It was a complaint apparently to the Office of the General Counsel. I have just moments before we came onto the record been informed that there is no written report. That is my best understanding. Whether or not there is some other kind of investigated information that exists has yet to be ferreted out. That effort, that process is ongoing. Ms. Michaels is correct in the aspect of phone records are being sought. All of the, just so the record is clear, all of the evidence and discovery that we have has been furnished to defense, but the investigation is ongoing.
Okay.
Whether or not 30 days is sufficient is a live and good question.
Okay, well, and let me just make sure that I'm clear. Whether 30 days would be sufficient for phone records is questionable, or for everything that Ms. Michaels indicated, I guess.
I believe my thought was everything, but I think that also applies to phone records. Quite frankly, Judge, I don't know what that timeline is. I can try to find that timeline out and communicate that to the court and counsel, but I don't have that.
Okay, and I guess I'm not, what I don't want to get to, I guess, is a point where we're at a certain point, it may be ready to be set for exam or do whatever, and everything that these records, I'm presuming, Ms. Michaels, that you're saying from the U of M, that are records from the U of M.
Correct. It's our understanding that when you just step back a touch from the actual incident, there were statements made and things done earlier that day to the U of M, statements made by the complaining witness that are going to be important to this investigation because her credibility will always be an issue, and different statements she made to different people will need to be evaluated. So those statements are important.
Okay, I get that, but aren't those documents or statements that you can get on your own, or?
That's a great question. I can issue a subpoena if the court is willing to sign a subpoena. I will send a subpoena myself, but I do know based on the police reports that the prosecutor's office is also seeking those documents. And in my experience, people are much more ready to turn over documents to a prosecutor's office than to a defense attorney.
And there it is, the subtle courtroom reality. Prosecutors often get faster cooperation from institutions than defense attorneys do. Not always, but often enough that it's a tactical consideration. That's why the defense is pushing for subpoenas signed by the court. This isn't just paperwork, this is strategic positioning. Whoever controls the flow of information controls momentum.
Guess
We may
that's,
quibble about that, but
yeah,
I
so
don't,
it depends on one's view of life,
but
but
I take no issue with just flowing it through us.
yeah, right. I don't have a problem with that either. It's just, I'm trying to figure out if the request is made. So, because are you attempting to try to obtain those documents?
I am.
Okay. And then once you obtain them, if you do obtain them, you're going to inform counsel or provide them to counsel. Gotcha.
One more thing, Your Honor, for due diligence sake, maybe I should submit to the court a subpoena for signature, and of course I'll serve the prosecutor, and I can also submit a subpoena requesting those records, having them returned to the court.
Well, having the results come to the court.
Correct.
Okay, and then we would. Okay, I don't have a problem with that if we're the go-between, that it comes here and then goes out. I don't necessarily have that, so unless there's some legal objection to it, if you submit a subpoena to the court, I would sign off on it, I guess, try to get this, so we can get this thing moving. 30 days. So, there's also, and just so that's the discovery. Today, I guess that was filed a motion to quash.
Boom. This is the power move. A motion to quash the arrest warrant challenges whether the warrant was legally valid in the first place. And a Franks hearing? That's even bigger. That's when the defense argues law enforcement may have included false or misleading information in the warrant affidavit. If the judge agrees, parts of the case or the entire case could collapse. This is no longer routine scheduling. This is foundational warfare.
That's correct. Earlier today, I, at the court window, filed a motion to quash the arrest warrant and a request for a Franks hearing. I have a signed copy to tender to the prosecutor, and we will be asking for a hearing date on that motion.
Okay, do you want two separate dates? I mean, how fast do you want? Well, first of all, I mean, the people have to answer. So
Sure.
I guess how fast do you want this?
This can,
And what I'm indicating to you, Michael, so I can set the motion along with the PCC, hear it all at that time, or I can give you a date for this separate and apart from the PCC.
I would like a date separate and apart. This motion is not determinative of those records. It is prior to those records. So a date to hear this motion prior to receiving those records would be our request.
Right, but I mean, presumably, actually, you're then talking about 3 hearings, because there's going to have to be a hearing on the motion to determine whether or not you'd be entitled to a hearing, an evidentiary hearing. Then, if necessary, I'd have to set the evidentiary hearing, and then we would also have the PCC.
That is accurate. So a suggestion may be to, whatever the court desires.
Oh, you don't want that. No, go ahead. Okay, that's fine.
You know, this is a lot. So in the expedience, we'll leave it to the court's discretion as to how you want to set
for
things.
that part of it, but we'll try to get through it as quickly and as expeditiously as possible. But the people have seen the motion. How long are you going to need to respond to the motion for the first part of it.
So although I was aware that a motion was filed this morning, I was not served with a copy until moments ago. I have obtained a copy through the court file prior to being at this moment and have had an opportunity to begin to flip through. I have not consumed it in its entirety. How long to respond was the court's question?
Yes. For the first part of a determination as to whether or not there would even need to be an evidentiary hearing in this case.
Notice how calm this all sounds. Scheduling, deadlines, dates. But underneath that calm is pressure. The prosecution now has a ticking clock to defend the warrant. The defense is betting that once the affidavit is scrutinized, cracks will show. Strategic tension doesn't yell, it sets calendars.
Court's pleasure, but at least a week.
Just a week. Well, I either decided on Monday, 21. 10 days. I'm just going to do it personally. 10 days. And just get to go through everything. So we'll have this time. Yeah. Will that work?
Yes.
All right. So with reference to the motion, I'll have the prosecutor's response will be due by maybe longer than a week, February 2nd.
Thank you.
February 2nd, 2026. I will then set this for hearing on the motion. For February 9th, 2026, at 1 p.m.
Your Honor, may I speak up?
Yes.
Moment, I have a murder case set to start on that date. That may change, even within the end of the day today, that may get moved. But in the moment, that is day one of the murder.
That's day one.
That's not a good date for me either, Judge.
You give me a date, let's see what we can figure out. Well, Tuesday the 10th is not going to work at the murder trial, folks. So
Tuesday the 17th at 2 o'clock. Should be fine.
That works for me.
at what time?
2 p.m.
All right. So the motion will be set for February 17th, 2026. You said 2?
Yes, sir.
At 2 p.m. Okay, and that will be an in-person hearing. We then, in understanding that, depending on the result of that motion, there may be another date that is set. But I'm not going to deal with that at this point because a determination has to be made. So I'll adjourn the probable cause conference. Normally I'm not really going to care about the date itself, but with some of the logistics that come along with this case, I have to because of other docketing concerns. Will March 19th then work? I realize that's a little bit longer than what you asked for, but we're going to see each other on the 17th. And then I would adjourn this out to the 19th, hoping that I'll discover, at least at that point, is good.
That works for the defense.
Works for me as well.
All right. So probable cause conference will be adjourned to March 19th, 2026, 9 a.m. or as your invite indicates. Is there anything else from either side?
Nothing from
No, Your Honor.
All right. Thank
you
you
very
very much. Bond will continue.
Thank you.
Thank you.
As this courtroom hearing comes to a close, one thing is clear: this case is far from over. What started as a routine probable cause conference quickly turned into a strategic legal battle. The defendant didn't just show up, he challenged the very foundation of the case by filing a motion to quash the arrest warrant, and in that moment, the entire tone inside the courtroom shifted. The judge listened carefully. Deadlines were set, responses were ordered, a separate hearing date was locked in, no chaos, no confusion, just controlled authority. But make no mistake, motions like this are serious. If granted, they can completely shut a case down before it ever reaches trial. If denied, the pressure only intensifies. This wasn't shouting, this wasn't explosive anger, this was something far more powerful: strategic courtroom tension. The prosecution now has to respond, the defense is preparing for a crucial hearing, and the judge will ultimately decide whether this case moves forward or faces a major legal setback. Every hearing matters, every filing matters, every decision from the bench can shift the balance of power in seconds. And that's what makes moments like this so compelling to watch. Because behind the formal language, behind the scheduling discussions, behind the legal terminology, there's a real battle unfolding. A battle of strategy, timing, and authority.
And here's the reality. February 17th isn't just another hearing date, it's a potential turning point. If the motion to quash succeeds, the prosecution may have to rebuild or risk dismissal. If it fails, the case moves forward with renewed force. So let me ask you, do you think this was a procedural delay or a calculated strike at the heart of the case? Because in high-level litigation, timing isn't accidental, it's tactical.
This hearing could change everything. Will the motion to quash expose a weakness in the arrest warrant, or will the court allow the case to proceed toward the next stage? One thing is certain, this legal fight is just getting started.